good afternoon, good morning, good evening, good night, wherever you are. Um, we are about to start a discussion on a really huge show, really huge issue at the moment, which is the future of global control over corruption. And it's pretty obvious why it's such a huge issue. Now, I recently wrote a book on the crisis of democratic capitalism. It was published a couple of years ago. And one of my main themes was that you cannot manage the connection between a market economy and a democratic polity if corruption becomes rampant. As soon as that happens, it destroys politics and the credibility of democratic politics, any form of open politics, and it also destroys the economy because it means the most successful business people are not the people who are actually providing goods and services successfully, but they are people who have the ears of or the direct control over power. So I regard this issue that we're discussing today as pretty well the core issue in, or certainly a core issue in contemporary politics, as well as in contemporary economics across the world. And it's in this context that we are having this discussion. And I'm going to start with three contributions before we get to some specific questions from people who have been very, very actively involved in the working group concerned with this issue from its inception after the famous anti-bribery agreement was reached. So I'm going to, and those speakers will be Mark Pieth, who chaired the working group from its inception until 2014, and Drago, who served from 2014 to 23, and Danielle Goudriaan, who's former head of the Netherlands Specialized Anti-Corruption Unit, who served from 2023 to 2024. So the opening remarks on where we are and the big issues that are being raised now, I think not least by Mr. Trump's administration, may I turn to Mark Pieth.
Yes, dear friends and colleagues, maybe just a few words of introduction first. I spent most of my life as a professor of criminal law. Before that, I had been head of the section on economic and organized crime at the Swiss Ministry of Justice. And there I was a founding member of the Financial Action Task Force on Money Laundering. And I have chaired, as you have mentioned, the working group on bribery at the OECD from 1990 to 2014, a very long time for a president, and various times I nearly got kicked out. Now, my approach to the topic, when I started in this role, the US were very pushy because they had given themselves a very tough law on transnational public bribery, the Foreign Corrupt Practices Act, and they were very much interested in leveling the playing field of commerce with their main competitors. And the topics of the day then were, okay, let's write a convention, let's implement laws, let's try to apply them domestically, and in order to see to that, let's monitor progress on applying. Those were the stepping stones at the time. But it's interesting, the critique that we faced in the early days were, well, the major competitors, take Britain, France, Germany, or Japan. They claimed that the US were approaching it as a mere trade issue, and it was all about an imperialist move by the US to force this on them. So it was kind of the contrary of what we're seeing at the moment. Now, I think we very quickly realized that going against foreign bribery might have this trade element in it, but it was primarily about promoting development, and reducing poverty. And I will come very briefly in the next round when I'm talking to what's actually happening now. And I will be quite outspoken.
Thank you very much. That gives us a very nice introduction to the issues. And I think one of the most fascinating things, as in so many other areas, noticeably in trade policy, which I followed for much of my life, the US was the initiator of the organizations, the laws, the practices which it is now, alas, attacking. As a journalist, I think I can freely say that, and it's a paradox, and it's an enormous challenge. May I then ask Drago Kos to set out how he views where we are and the issues, the sort of the broad issues of the situation we're now in.
Thank you, Martin. Well, good afternoon from Slovenia. Let's say, brief introduction. I was the first chair of the Slovenian Anti-Corruption Commission. I was chairing the Council of Europe group of states against corruption between 2003 and 2011. I was the chair of the Working Group on Bribery, the OECD, between 2014 and 2022. I'm still chairing something which is called the OECD Istanbul Anti-Corruption Action Plan, which is basically monitoring anti-corruption activities of the countries from the Eastern Europe and Central Asia. And last but not least, I'm the interim dean of the International Anti-Corruption Academy in Vienna. As you can imagine, I'm teaching a lot about corruption, and when I talk to different audiences, I always tell them the same thing in the last year, which is it has never been more difficult to fight corruption internationally. The conditions for that are worsening from one day to another, and I'll just list some simple reasons for that. The first one, of course, is the new US president and the actions of the new US administration. Then we see something which I call the empire striking back in the Lava Jato case in Latin America. I see, let's say, cases involving major companies from Europe, namely Iceland, Italy, the Netherlands, and the efforts of European law enforcement agencies are basically lagging behind the efforts of the African law enforcement agencies in those particular cases. Then, what is also important is that fighting corruption is clearly losing the importance in today's world. Namely, the world is facing phenomena such as genocide, war crimes, terrorism, extrajudicial executions, piracy. And of course, at least for, let's say, for many of those phenomena, corruption is objectively less important. And we can see that in the interests of the countries which are basically either engaging in other areas much more actively than they do in the fight against corruption, or they simply do not want or do not feel that they would also have to engage in the fight against corruption. Some people might say that, let's say, in Europe, because I'm coming from European Union, situation will improve soon with the new and upcoming EU anti-corruption directive. But I'm afraid that knowing that its content, that those people will be disappointed again, because this directive, as you will see when it will be adopted, will be very, very weak. So we don't live in rosy times to fight corruption in the world.
I think that has to be right. Every area I look at of important policy is a shambles right now, and this is inevitably one of the most important casualties of this disturbing moment. So may I now turn to Danielle Goudriaan to give her perspective and her background and her view of where we are.
Thank you very much, and I'm very happy to join this discussion, although happy is not really the right word because I get a bit depressed after the previous introductions already. it's difficult times indeed for anti-corruption. And I was thinking about it, and it's actually that the architecture, the global architecture of fighting corruption is under pressure. It's changing, and I think that the discussion on the OECD Anti-Bribery Convention and the Working Group on Bribery should be situated in that discussion in this geopolitical landscape we're in at the moment. And we see a troubling trend that there's more and more unilateralism among these major powers. As we all know, is that the United States, for example, recently has taken steps to withdraw from several United Nation bodies and frameworks. And these developments raise serious questions about the future of collective action on cross-border issues like anti-corruption forces, but also other corporate accountability or cross-border issues relating to the rule of law. And within the OECD itself, we also see it. The Global Minimum Corporate Tax Framework, which was agreed in 2021, pushed by the Biden administration, and was designed to counter harmful tax competition and profit shifting. And the recent update was that there was a carve-out for the US, for US-based multinational following political pressure from Washington. Here also there is a risk diluting what was meant to be a global standard, and it may undermine the efforts to address practices that often relate to risks for corruption and other fraud risks. As just mentioned by Drago, at the same time, we have the European Union is moving forward with the Anti-Corruption Directive, the first one. And as Drago already mentioned, there is not a definitive directive yet, but as we have seen from the negotiations and the news that we see about it, it has been watered down quite a bit. So indeed, it will be more disappointing than what we were expecting in the beginning. So taken together, these developments, they highlight a recurrent tension in the global governance between national political priorities and collective commitments to transparency, fairness, accountability. And it's not an abstract thing, this tension, because it directly affects how laws are going to be enforced, how prosecutors will operate, whether the anti-corruption framework will be really deterrent if it's still left. So in that backdrop, we have to have the discussion today, I think, on how the OECD will be in that landscape. And as you just heard from also some things I pointed out, I have a background in prosecution because I have been a prosecutor for 20 years. I've been the first Dutch prosecutor in the European Prosecution Service in Luxembourg. And for a short time, the chair of the OECD Working Group on Bribery. So I always look at this also from a practical view, and maybe we also get to that, is that what's all happening in politics, what does that do with the people that are working on the ground on these cases? A lot of people are still very committed to fight foreign bribery in all countries, but will they still be able to do that, and how can they be helped?
Thank you very much. It's very, very useful. I think we've still got a couple of minutes or maybe 3. And I have a question because I don't want to leave this too depressing before we move on. Would one of you like to comment perhaps more very, very briefly on, it's obvious we have some really big problems in the developed world, and we've discussed this. But this is, of course, an issue that affects the whole world. And many, many developing economies, and I worked on them. I was a senior economist at the World Bank in an earlier phase of my career, have been very concerned about the impact of corruption on their economies. Are you seeing that there are other parts of the world where concern is actually rising about corruption and the importance of controlling it, as against what seems to be a rather adverse trend in the developed world? Would somebody like to comment on that? Mark, would you like to say something on that?
Yes, I can. Well, frankly, it's actually quite amazing because so far concerns have been all over the world Take multilateral development banks, they have been very worried about rising levels of corruption, but they've also, let's say, in their analysis found that we are making some headway. And what we're now experiencing is putting a lot of it in question. I mean, it's really a big issue, what is going to happen in the next few years, actually.
Drago, would you like to comment on this sort of the worldwide attitude to this and your perception of how far at least there is concern about the direction that is happening and the worry about it?
Yeah, I have to say, let's say that countries from Africa and then let's say in Asia, especially countries from the Gulf, are engaging heavily now in the fight against corruption. Of course, not at the level of the investigations and prosecutions yet, but at least they show a lot of interest in developing anti-corruption measures in their countries. We will see how this will materialize and how this will, let's say, finalize in the court or the trials, if there will be any trials for the, let's say, especially high-level corruption cases. But it's undoubtedly clear that, let's say, the African and Asian countries, and English especially, as I said, the Gulf countries, currently are much more engaged in doing it than let's say, the developed world.
That's very, very interesting. Finally, Danielle, do you have anything more to add to what you said earlier on this point?
No, just shortly on what Drago just said. We do see. We also saw it or see it in the working group on bribery that some Asian and Gulf countries are more active, trying to engage or even join. Although I'm very curious what will happen in the next few years if the situation will stay the same in the West. Will this push, which we have seen the last few years, will continue, or will there also be some backsliding?
Yes, I think this is an immensely important question. We have to remember that we're not living in quite the same world as before, and developing countries, a huge group of very diverse countries, have agency, and it's an issue for them too. And I think they're going to have to play a bigger part in such discussions if things are going to improve. And now I've been given a long list of questions for each of the panelists. That will last about 40 minutes or so. But then towards the end, we'll have questions from the audience. I think you all know, I hope, how to pose them. If not, I'm sure I can come back and tell you about that. But there are obvious ways through the chat feature. But you will have the opportunity to get your questions, at least some of them answered towards the end. So let me start the questions. There are 11. So try and make your answers brief. And of course, if one of the panelists really wants to add something, just put your hand up in the normal way on Zoom. Yes, I've been told here you need to use the Q&A button. Not the chat button, but the Q&A button. Fine. Okay. The first question is for Mark. In February 2025, President Trump suspended the Foreign Corrupt Practices Act, which is the primary anti-bribery law in the US. The president said that, and I quote, "Current FCPA enforcement impedes the United States foreign policy objectives," close quotes, and that prosecuting US companies, quote, "for routine business practices in other nations," close quote, "was actively harming," open quote, "American economic competitiveness and therefore national security," close quote. Is he right? Or could this become a slippery slope to a briber's charter? Or I would say, is it both? Mark.
Well, indeed, you won't be astonished if I say I disagree entirely. The DOJ has run at least as many landmark cases against foreign companies as against US corporations. Just think of Siemens, etc. Now, what I think this policy of pausing or reconfiguring the prosecution strategy is really leading to is pushing us back into the times of post-colonialism or the times after the Second World War, where we had a kind of a Wild West situation where everybody was trying to get a piece of the cake. And you were bribing to get mining rights. We were bribing to get drilling licenses, etc. This has never really stopped, but it was in those days accepted. You could, in most G7 countries, deduct bribery from taxes. Now, this has definitely changed with the convention, and we're kind of being pushed back into that situation. Where does that leave? Well, in my view, it is an invitation to rob commodities of commodity-rich countries, but otherwise quite poor countries in the South. And frankly, it might backfire. It could be an invitation to solicit US companies for bribes.
This seems all too plausible to me. Would either Drago or Danielle add anything to the significance of this backsliding in the US, which was the focus of the question?
Well, I'll be speaking about it and the answer to one of the next questions. So,
okay, in that case, we can move on. So the second question, which is actually for Danielle, is as follows. In a letter to US Attorney General Pam Bondi criticizing President's suspension of the FCPA, all of you pointed out that most defendants in enforcement actions under the Act have not been US businesses, but foreign companies and individuals. Why should the US be the one to enforce the OECD Convention? Isn't it time that others honored it through prosecuting their companies? Danielle.
Yes, thank you. Yeah, I think the United States should not, and it was never meant to be the sole enforcer of the OECD treaty, the Anti-Bribery Convention. The idea was that everybody would dive in and take their turn in enforcing. That said, of course, we have seen that how enforcement has worked in practice, and for many years, the US acted where others did not. That was not because the convention made the US having that role, but because the enforcement capacity and political willingness in many countries lagged behind. There were legal commitments. A lot of times we see that there's a lot on paper, which looks very good, but then having results in cases lags behind. And so as a result, the US jurisdiction became almost a substitute for domestic enforcement elsewhere. So the response to this imbalance should not be disengagement from the US and say, well, why are we the policemen of the world all the time? But the others should step up, because if the US steps back, well, the others still do not enforce robustly, then there will never be a level playing field. And I think that it is long past time for other members of the convention, of the working group, to honor the commitments that they pledge to. But I think it only will work if everybody move forward, and not if one of the strong enforcers will move backwards and give the signal that it's okay for everybody to choose their own country first and not engage in these difficult cases.
Yes, that seems to me to make a lot of sense. I'll move on to the next question, unless somebody wants to add something very powerfully here. But I think actually the next question to Drago will actually bring this together. So how would you address the unlevel playing field that President Trump rightly complains of? Do the new guidelines issued by the Department of Justice in June 2025 do the job? Where do they leave the US?
Well, let's say it is like the Bible that everybody reading the FCPA and the OECD Anti-Bribery Convention knows that the final aim of these two legal instruments is to exactly to level the playing field for all companies of the world. So when the President of the United States is complaining against what he calls unlevel playing field, basically, I'm afraid he wants to say that for the US companies, this field has to be more even than for the others. This is what he also said in his executive order when he paused the enforcement of the FCPA, because in this order he explicitly instructed the DOJ to issue revised policies designed to, and I quote, promote American interests. Promoting American interests. Such a policy was then issued by the DOJ in a form of guidelines for investigations and enforcement of the FCPA. And from the number of elements, it can be easily concluded that that non-US companies will be investigated as a priority, and the US companies will only be investigated in certain cases, and what is also important, under a strict supervision of the political appointees in the DOJ. Namely, the guidance foresees the approval of the high-level prosecutors in the DOJ at the level of political appointees for every investigative action in accordance to the FCPA. So, and many of the elements which are represented in these guidelines also represent a clear breach of Article 5 of the OECD Anti-Bribery Convention. You know, Article 5 of the convention is basically, at least for me, the core article of this, and not only this, but also all other anti-corruption conventions, because it prohibits, let's say, the inclusion of elements such as, let's say, the economic importance of the suspects, either natural or legal persons, diplomatic relations with other countries, or identity of the investigated or suspected persons in the investigations and prosecutions. Basically, what this article is asking is very clearly a guidance to the investigators, prosecutors. You stick to the merits of the case. You don't take into consideration anything else. And let's say from my work in the Working Group Bribery, I can say that, let's say, when any country received a criticism related to Article 5, they normally reacted very strongly, because they knew that basically, if I put it in very plain words, that means that they are politicizing the investigations and prosecutions of their cases. Now, based on this, first of the suspension and now on the guidelines, it is clear that the US authorities will significantly soften the approach when dealing with the US companies and strengthen it when dealing with the non-US companies. And this is what the president has asked them to do. And this represents a huge problem now, which might lead, let's say, to many consequences, not only in the US, but also in other jurisdictions.
So this is, if I may translate that into my sort of language, a real crisis for the system, because the US view of what a fair system is fundamentally and irretrievably partial, and therefore cannot be universalized. And then, of course, it becomes a race to the bottom among all jurisdictions trying to protect their own companies from any form of global jurisdiction, which ends up as no jurisdiction at all. Is that sort of where you're going with these, if I understand what you're saying?
Well, it can also, the opposite can also happen. Namely, we already saw, let's say, that some jurisdictions, namely, I think it was France, UK, and Switzerland, are trying to step into this loophole, and they're stepping up their efforts, which means it does not necessarily have to happen that other countries will also slow down. It might also mean that other countries will push the pedal, and they will be, let's say, become even more rigorous in fighting international corruption, especially when the US companies will be involved, because they will know, the law enforcement authorities will know that US companies are not under such a scrutiny back home anymore. So they might step in, and they do it.
I think that's very interesting. And of course, but there is an issue which I don't want to push further because it's obvious that this US administration might well use other instruments to punish governments that do that. And we have form on this. Just look at the way they've been using tariff policy as a means of punishing governments for actions which have nothing to do with trade policy. This is obviously one of the issues we face. But let me move on to the next question, which is also for you. Yes, what has been the impact of the FCPA suspension in the US elsewhere? And what signal has it sent to other countries? Have there been verifiable impacts on other countries?
Well, I have to say that there was legal and ethical shock when the FCPA enforcement was suspended. Legal, because not one single US or international legal norm foresees the possibility of the enforcement suspension. And ethical, because it became clear that the US, as the former flagship of the global anti-corruption efforts, is changing the course. And the latter has two dimensions. First, the world has lost the leader in the anti-corruption efforts, which was also often serving as a model to follow by other countries. But not only leader, but also strict monitor of anti-corruption activities of other countries, which were sometimes doing things in the anti-corruption area simply because they were fearing of the US reactions. Now, they know that this will not happen anymore, and this for sure will have the consequence that there will be countries simply saying, oh, if the US is not doing it anymore, why would we? And countries which won't do it anymore, since they would not need to be afraid of the US reaction. Well, since the question is about the verifiable impact, I have to say that not enough time has passed yet to make the necessary analysis and collect the evidence, but I can tell you the anti-corruption experts and practitioners already feel the loosening of the anti-corruption grip around the world, if I may say so. And fighting corruption is not, in many countries, not so important anymore. So I'm afraid, let's say, the first verifiable impacts will appear maybe this year, because that will now be 1 year already. We have statistics going down for sure. In the US, we see, let's say, that many FCPA cases were simply closed after the suspension entered into force. So, but the whole extent of the damage will be seen in a year or two to come.
This actually leads very well to the next question, which is for Mark. And it says the last monitoring report of the US undertaken by the OECD Working Group on Bribery was in 2022. If the impacts of the US pausing the FCPA are so serious for the convention, why has the OECD been so silent? What could it have done, but hasn't?
Yeah, that's indeed very puzzling, and especially in view of what we've been doing in the past in such situations. We've actually got a procedure for somebody slipping back. I'll give you two examples. When Berlusconi of Italy, as Prime Minister of Italy, was accused personally of false bookkeeping, he attempted to abolish the offense in the criminal code, falso in bilancio. And then we asked the government to turn up and explain what they were doing, because that was squarely against Article 8 of the Convention. They were forced to explain themselves, and ultimately they didn't do it. The other example is probably even more blatant. You know, the UK of Tony Blair, where Tony Blair ordered the closing of a case run by the Serious Fraud Office, the SFO, the case on BAE called Al Yamama. It's the Saudi fighter deal. We stood up. It needed something because it was quite tough on the working group. It did not have to do with diplomatic ways. We stood up, and it caused quite a stir. There were 100,000 media products as a follow-up to our voicing our anger. And in the UK, there was parliamentary action, judicial action, and ultimately, I believe that this law that was then written, the UK Bribery Act, which is allegedly one of the toughest laws in the world, is probably the legacy of this breakdown. So I think one can actually do something, but it is difficult if a country simply and squarely opts out of the consensus. And I believe the fear is that the Trump administration would, in the first place, simply cut the OECD's budget. I think that's a very real risk. You mentioned punishing governments. It's not excluded. The difficulty there is, of course, that governments and judiciaries are not necessarily aligned. So a French, British, or Swiss judiciary may pick up a case, and if Trump doesn't like it, he can turn against the country or the government. But the judiciary is independent in a democracy.
Well, that's sort of an optimistic view, and I hope it's true. That these are really obviously incredibly important issues. Now, the next question I have here is for Danielle. In its 2022 review of Italy, the OECD concluded that the acquittal by the Milan court of two major European oil companies, Eni and Shell, for alleged bribery relating to the purchase of the OPL 245 oil block in Nigeria did not accord with the convention. In particular, concerns were raised over the court's handling of circumstantial evidence. Why was this so problematic, and how did it conflict with the convention? Danielle?
Yes, thank you. Yes, the concerns of the OECD at that point were not as much about just criticizing or second-guessing national courts, which was something that Italy pushed back on heavily. But it was about whether foreign bribery can still realistically be prosecuted under the circumstances, the standards that were applied in this case. And, in foreign bribery, almost never you have a smoking gun. You're always, of course, looking for the email where it says, I will bribe you here, and then you give me this, but that will never happen. So you have to search for this circumstantial evidence, patterns of financial flows, intermediary conduct, internal communications, inconsistencies. And that is then cumulative circumstantial evidence. You have to put it all together. This is actually recognized amongst many jurisdictions. It's actually a best practice internationally to take all these pieces together and lay the puzzle. And in the OPL 245 judgment, the Milan court appeared to dismiss this approach of adding up all these little parts of the puzzle and required a level of direct proof that is exceptionally difficult to achieve, especially in these complex international corruption cases. So the risk was that this sets a precedent in other cases, both nationally in Italy or internationally, to make it really difficult to prosecute sophisticated bribery schemes. So. And this kind of approach could conflict directly with the convention's requirement that parties ensure that they have legal frameworks that allow for effective enforcement. As I said before, on paper, many times it looks really beautiful and perfectly in order, but you should also be able to get convictions in court and it be realistically. So this is why the working group raised their concerns. Haven't they raised the bar too high? And this should be really looked into.
That seems pretty convincing to me, and it looks as though the question 7 follows directly from this, and it's to Mark. Article 5 of the OECD Convention prohibits political interference in bribery investigations. An external lawyer for Eni has been convicted in Italy, and a former Eni chief counsel is currently being prosecuted for interfering in the OPL 245 investigation. NGOs have identified 60 possible Article 5 red flags in the case and its aftermath, and yet no action has been taken by the OECD. Is this something that you think the OECD Working Group on Bribery should be looking into? What could the working group do? Mark?
Yeah, well, it takes us back to Article 5. And Drago has already mentioned that Article 5 could theoretically be a powerful tool. We've seen that in the case that I mentioned, Al Yamama, the United Kingdom. But you have to realize that naming and shaming really only works amongst people who can be embarrassed. To give you two other examples here, or another example, which was actually quite interesting. Sweden, flunked the exam in phase 2 because it became obvious that they had closed 10 cases against Saab Gripen for political reasons. And then the working group simply said, well, this is just not on. We will revisit you in a half a year. So the exam is stopped. Now, regarding Italy, I don't know the details of the case, obviously, or not well enough, but I think it is certainly the duty of the working group on bribery to follow up on the allegations and indicators of political intervention. That is absolutely clear. Well, you know, the word that I have not used in my last intervention maybe needs to be said. A lot of this is about cowardice.
Yes, that's obviously not surprising and pretty obvious, but it's a good thing that you've said it. As a journalist, I come across a lot of it. pretty obviously, and you can see it all over the world right now. So, question 8, which is for Danielle. The working group recently undertook a high-level mission to Peru over possible Article 5 offences. Why no similar visit to Italy? My God, Italy is a very bad boy here, isn't he? Is this a case of one standard for countries from the global south and another for those from the global north? Danielle, what do you think?
I think actually this was for Drago, but the next is for me.
Oh, it's okay. I go
Okay.
to Drago. Your name is definitely here.
Yeah. Well, if you don't mind, I will try to answer this. You see?
Yes, of course. No, I don't mind at all.
So I had to read a lot. So I understood that the high-level mission to Peru happened because the WGB, the working group, had concerns about prosecutorial and judicial independence in the country. There are countries in the same region, especially, let's say, Brazil and Argentina, where their prosecutors and judges have even more serious problems when it comes to their independence. But there were no high-level missions lately. I remember, let's say, Brazil, we did something in 2019 or something around that. And we can say, and the working group has said it already, that the same for Italy when it comes to the independence of prosecutors. And as we heard earlier, for the US, and none of them is facing such a high-level mission recently. So now this basically shows us that it is not the division between the global south and north, which is a decisive element, but there has to be something else. I'll say I want trying to understand why such a mission did not happen to Italy. Of course, I know that this high-level missions always impose a heavy workload on the working for bribery, but I guess that this is not the reason for the absence of the high-level missions needed for some countries. Obviously, the WGB members, and I have to say it's, of course, let's say OECD as secretariat has important role in running the Working Group bribery, but it is the countries having the final say. And obviously they don't want to do that. There are people saying that they don't want to do that because they don't dare to touch big countries, because these big countries are big financial contributors. This is something which Mark has mentioned already. But I hope that really this is not the case for the OECD and the WGB. And the Mark in his last intervention used the word coveredness, which could also be here as one possible reason for why this is not being done. But one way or another, it is extremely, let's say, well, I cannot say tragic because this is a bit exaggeration, but it is extremely unpleasant that the Peru faces such high-level mission, which is one of, let's say, of the extreme measures which the Working Group bribery can apply against the country, and some other countries which are obviously having much more serious problems that don't follow the same path.
Thank you very much. Well, yes, it does seem that justice is not equally served. So the next question was also put down for you, Drago. It says, in a twist to the OPL 245 case, Italy has prosecuted and convicted the trial prosecutors for allegedly withholding documents from the defense. Jurists in Italy and elsewhere have expressed grave concern that the convictions drastically limit prosecutorial discretion. Why is such discretion so important, and how is this impacted by this case? Should the OECD, again, be expressing concern? Drago?
Well, Martin, I don't want to be the one speaking all the time, so if you don't mind, I'll pass this one to Danielle.
Danielle, okay.
Thank you.
Mark seems not to be there anymore. I don't know.
I think he's hiding.
Oh, he is there.
Yes.
Just hiding. Okay.
No, I can say something about it. Just one moment to get back to what you just asked Drago about the high-level missions. Actually, also during my time as the chair, money and also people in the secretariat was also an issue in doing high-level missions, other travel. So there had to be a cutback even on the amount of high-level missions that were even possible. Still, then you can look on which are the most important one, and I'm not sure if that then is Peru or another country. It's still almost a political choice which country you will then put first. On the OPL case again, the discretion of prosecutors is very critical. It's very important. And what we've seen in this case is that the prosecutors made a decision in the case on evidence, which prosecutors do all the time, every day. And if something should be criticized in that sense, maybe something went wrong, I don't know, that can be done. And there's a court for that. You can fight it in court within the criminal. But what happened here is that they were actually prosecuted afterwards for taking the decision they did, is something that was like it has never been seen like this. And it has such a chilling effect, because if a prosecutor makes a mistake or does something different than other people would have done, and we're in criminal law, you can always discuss about what's right, what's wrong, how it should have been done. And then you get prosecuted for this. So this is, if you face criminal liability for good faith decisions, everybody's going to be afraid. There's no discretion. There's going to be, you can avoid taking difficult decisions, taking difficult cases, because what if you're wrong? What if something happens? So there was an alarm when this conviction came beyond Italy. Worry about the independence of the prosecution, about the discretion that they have had. So this goes also to the heart of this Article 5 we discussed before. And the OECD should be concerned and at least dive into this, because as we heard before, Article 5 is one of the most important elements of this. And we haven't heard a lot about it from the OECD.
Okay, that seems pretty clear to me. So this is another question put to Drago. Is Italy the only country where there are concerns about possible breaches of Article 5 of the OECD Convention? For example, what do you make of recent developments and the handling of the car wash scandal in Brazil and Peru?
Well, Martin, I think Mark's hand is in the air, so maybe he would like to add something in relation to the previous question.
Yes, Mark, go for it.
Yeah, I was just wanting to throw in something on that visiting a country. I think it was mentioned that that's one of the heaviest sanctions you can imagine. But frankly, I'm not really convinced by not going to Italy, because I remember that I think it was 2008, we went to the UK. I remember 10 countries from the working group visiting the Foreign and Commonwealth Office, and actually Brazil telling the UK how to write a law. That was technical assistance from Brazil to the UK. It was rather spooky, I would say, but so they all had enough money to travel to the UK and help in the birth of the UK Bribery Act.
Okay, that's interesting. I'll have to think about what that shows. Perhaps it shows that people rightly regard the UK as very friendly and cooperative. Have to believe that. Final question is for all three of you, so give brief remarks at the end. The United Nations Convention Against Corruption recognizes the vital role played by civil society in combating corruption. During your times as chair of the working group, what did you find that the NGOs brought to the table? Let me start with you, Mark.
Yeah, I'll start with 1994 to 1997. It's interesting there, namely Transparency International played a huge role. They were just founded, and their role was to convince reticent business communities. I'm thinking again of Germany, France, UK, especially. They were convincing the business institutions to join the efforts and actually to bring about the convention. It was a very specific moment. And after that, I think civil society in general had always taken part both in meetings with the working group and then in monitoring visits. So they played an essential role from then on.
That's very, very interesting. Danielle, perhaps you could comment on this question?
Yes. Well, actually, maybe Drago can say something about it, because the 2021 recommendation was written, and there was also a part on keeping the NGOs, for example, more close, or at least take into account what they have to say. And actually, what I saw is that you saw the NGOs always with the country visits in the monitoring cycles. They were interviewed, they gave input. But at some point, we also saw some NGOs being more active and raising issues outside of these monitoring circles, and flagging issues ad hoc. And what I did see was there a lot of the countries were a bit hesitant how to react on that. And actually, I think that the NGOs can have a good role in that, flagging these issues in between the meetings and the monitoring. And it also depends a bit on which NGO, of course, does it. And also some countries have better experience with NGOs, have better relations with them than others. But I think that their role can be quite important and also in the future.
And Drago,
Yeah, well,
what is your view on this, the question?
see, the fact is that in your question, you mentioned the United Nations Convention Against Corruption, which indeed is putting a lot of emphasis on the civil society involvement, which is not the case with the OECD Anti-Bribery Convention. And the Working Group on Bribery is dealing with the OECD Convention only. That means that whatever you heard until now from let's say, from Mark and Danielle, and what you'll hear from me is basically simply the not the legal obligation, but our desire and desire of the whole group to give more important, let's say, position to the civil society. So, let's say, in my time, we started with some basic stuff, which is basically publicizing the minutes of the meeting, arranging a larger number of meetings with the civil society or private sector. But Danielle mentioned the most important one. You know, when we were drafting the 2021 recommendation, there were I think even three exchange of views with the civil society and private sector representatives, which helped us significantly, not only to understand what they do expect from a legal instrument, the upcoming legal instrument, which finally saw the light under the title 2021 recommendation, but also how they see the solutions in such a legal instrument. And I have to say, the solutions, not all, of course, but many of them were very good. So, and let's say the biggest reward for all of us at the end was when, from the civil society side, of course I speak generally, not for all elements of civil society, and from the private sector, we got the recognition that they were able to say something and that we were listening to them, which at least was important to us and which also is reflected in, I think, or I hope, in the good quality of the 2021 recommendation.
Thank you very much. We've come sort of to the end of this very informative, at least for me, very informative series of answers to these questions. On the Google Doc document Google Doc I have, there are 7 questions, and we've only got about 15 minutes, so you can work out roughly how long we have for each. I don't know who to ask some of these questions, so I'll be heroic and try and spread it around among you in a reasonably even manner. And I think they're all very interesting, so I'll take them in order. Nicola Bonucci, former OECD General Counsel, obviously a very qualified person, asked the following question. In 2017, Rex Tillerson, former CEO of Exxon and at the time Secretary of State, pushed back against the first attack from Trump against the FCPA. What is today's position of the corporate world? Are they showing any glimmerings of concern about what's happening? Does any one of you feel competent to respond on that question? Mark?
Yeah, I can try, but I have not really, and I'm astonished that I have not heard of any corporate entities actually actively pushing back. It's astonishing. It's rather the other way around. One asks yourself, well, who told Trump that this was a real issue? I mean, there must be members of the US corporate world who are afraid of the FCPA, who whispered into his ear. And so far, I think we have another element of people simply being afraid to raise their voice.
Well, if you look at the policies of the Trump administration on a whole range of issues, climate, diversity, equity, inclusion, for example, corporate governance, all these sorts of questions, the business community in various forms, the Business Roundtable, for example, has been very, very outspoken in the past, and it's all disappeared. So it seems to me the plausible explanation is, as you
Mark,
say,
can
that
I add
they're
something?
frightened.
Can I add
Sorry.
something here?
Yes, of course.
Let's say during the first Trump presidency, we had serious exchange of views with the US representatives in the Working for Bribery. Basically, and their position was very clear. They said, we will do our job as we did it until now. You just have to keep us keeping the low profile. And this is what we did throughout the 4 years of the Trump's presidency, because we didn't want to alert him that there is something which might be a problem, any sort of problem for the US companies. Obviously, and here I'm also only mentioning this because I do agree with Mark. Somebody has whispered something in his ears, because if he was not able to identify the problem during his first presidency, and nothing changed in the working methods of the working group on bribery between the first and the second presidency, it's obviously that for the second time, somebody told him, listen, there's a problem. There's something we have to do there.
Yes, it's pretty obvious that the second term is very different from the first term, and this will be one respect. Let me move on. This is from Maria Brigitta Schnebly, I apologize. The real and ongoing concern regarding Italy in the OPL 245 case is the prosecution of the prosecutors who had investigated the case. I tend to think we've covered that pretty well already. So I'll move on. I hope that's the case, that we've covered it adequately. Danielle Balint-Curti, could you elaborate, this is to Drago, by what you meant by, quote unquote, the empire striking back over Lava Jato? And more broadly, I'd like to hear what the panel members think of the way Italy handled the prosecutions over OPL 245. That I think we've dealt with. But is there any more you would like to say, Drago, on the empire striking back?
Well, this is the shortest way to say that, let's say, the police investigators, the prosecutors, and judges, for simply doing their job in investigating, prosecuting, and adjudicating corruption cases, are exposed to serious retaliatory measures. Sometimes the trigger for that is a political change, as is the case in Brazil. We have a person who was in prison for his role in Lava Jato case, is now presiding the country. Sometimes the trigger is the size and economic importance of the suspected companies. It's obviously the case in some European countries, which basically means altogether that what I stated already, that, let's say, countries feel that protecting themselves from corruption in many of them is now considered far less important than protecting other interests, their political or economic ones. And this is, let's say, and what happens right now, not exactly in the area of corruption, but let's say when you have the president of the most important country in the world saying that the international law is not important at all, I'm only afraid of the day when this will spill over to the area of corruption, which for sure it will. And I'm afraid that we will face even more serious problems then.
So that question actually, that answer brings us back to very, very well to the next question, which is from Gavin Heyman. He says, are there any bright spots in the world's anti-corruption architecture and I suppose practice too? Are there any hopes for the UK's coming illicit finance summit being led by Deputy PM David Lammy? Anyway, Danielle, would you like to talk about some bright spots anywhere?
Anywhere we can find them.
In this, well, not anywhere, but in this area of anti-corruption that we've been talking about, because it's been a pretty depressing conversation so far. Realistic, I'm sure.
Yeah, I'm not sure I can be of help to find many bright spots. As I said before, the EU directive is a bit of a disappointment. But at least there is a EU directive. And what we also see is that, for example, countries that are now getting ready to join the EU or are very busy at trying to get their anti-corruption framework up to standards. So that isn't gone, thank God. There's still something there. And I hope and trust that if we survive the next few years, that things are not that damaged and we can continue. And like Drago said, there is this task force from Switzerland, UK, and France, which I'm not sure that in practice makes a big difference, but it is a hopeful sign that countries in Europe say, okay, we're not letting go. We keep on going. And I really, really hope that there are more countries in Europe, and especially also my own country. I hope that they will join to at least give that signal that it's not all hell and purgatory. So there are some bright spots, and not everything's gone, but it also depends a bit on how long the race to the bottom is going to last for now.
Yes. Does either Drago or Mark want to add to that, or you basically agree this is the situation? Okay. The next question. Let's see. I think the next question we basically covered. Does the US abandonment of the G20 Anti-Corruption Working Group under its G20 presidency in 2026 matter? Could the UK bring it back in 2027? Would any of you like to talk about the role of the G20 as opposed to the OECD in this? Is it in any way likely to be significant? Largely the same countries, at least not largely, but the big countries are the same. Does anybody have any views on that?
Well, there has always been close connection between the G20 and the Corruption Working Group and the Working for Bribery.
So I assume, yes.
But let's say if one of the group goes passive, which I'm afraid we heard it might happen with the G20 anti-corruption group, the Working for Bribery will not feel influenced by that at all. So they will continue their job, hopefully, and just hoping that, let's say, this nightmare will be over soon. The only problem is, let's say, you see, it's not just the philosophical problem of somebody not wanting to fight corruption anymore. It's also a very practical problem because or basically they are using excellent investigators, prosecutors, and judges. And when the nightmare is over, I'm sure that not all of them will want to come back to do it again.
Yes, that makes sense. There's another question here for you from Robert Ross. Beyond the policy, legislative, and judicial levels, what role does transparency in process execution play at the grassroots level? Do you have comments on that, Drago?
Well, people sometimes think that transparency is the silver bullet in the fight against corruption. Yes or no? Let's say in countries where they never heard about transparency before, of course, this can help a lot. And when when the citizens get access to public information, of course, this is a huge achievement. But even transparency has its limits. So normally, usually the Nordic countries are the ones with the lowest levels of corruption. And there are many reasons for that. And one of the reasons is also the extremely high level of transparency. But when it gets to the problems, transparency will not help us much if we don't have effective and, say, impartial investigations, prosecutions, and adjudications. So yes, we have to work on transparency a lot, but don't expect that it will solve all our problems with corruptors.
So we've got 4 more questions in about 6 minutes, so adjust. The next question is, and I apologize if I get the name incorrectly, from Juliet Ibekaku Nwagwu, who's from the University of Sussex Africa Centre here in the UK. We found that most penalties or awards do not recognize the victims in developing countries, even though this is one of the rationale for anti-bribery and corruption rules and UNCAC Article 35. In this way, how would the panel consider leveling the field to allow the interests of the countries where harm was caused to be central to investigation and settlements. Does any one of you want to comment on that question?
Yeah, I
Yes,
think
Mark.
I can throw in a thought here. I mean, this has been a discussion with NGOs for quite a time, and it's been sparked off especially by the policy of the Department of Justice, not only during Trump, but before, where the Department of Justice basically was filling the coffers of the Treasury with those hundreds of billions. And very frequently, the people suffering most, especially, well, southern states and their population, were ignored. And I think that is a very crucial point to pick up. So far, what I've been seeing is that there has been stiff opposition, and that already under the older administrations in the West.
Okay, that's very helpful. So we have three more questions, fantastically quick. David Bernstein, this again follows up on the previous question, and I asked earlier, a question I asked earlier about the developing world and its interest in this theme. What can and what is the OECD Bribery Group doing to support civil society-led corruption efforts in developing countries? That follows on from this previous question, but it's not quite the same question. It's about the interaction between the OECD's working group and civil society, particularly in developing countries. Would one of you wish to respond on that? Danielle, would you have any views on this?
Yeah, well, I don't think that the OECD Working Group is really supporting these kinds of things, because that's also not in the treaty. It's not a job of the working group. But of course, especially, for example, in detecting cases or helping to advocate prevention of corruption. So countries are asked to work with NGOs. So through the monitoring and through recommendations in that sense, they weigh in on this issue. But there's not a real support from the working group itself.
Okay, I'll have to move on rather brusquely, we're running out of time. Penultimate question from Elizabeth Avila. Well, we've had a very recent new event in the world of unknown significance, namely what's happening in Venezuela. And the question she asks is, this looks like an attempt at creating some sort of fast track for US energy companies to invest in Venezuela. Though it doesn't seem from what we've seen very recently that they're terribly enthusiastic, not surprisingly. But what is your view of this from a regulatory perspective? Is it worrying, more worrying even than usual, or just one of these things we should expect nowadays? Drago, would you like to comment on this? Any views on what's going on now in these extraordinary interventions in Venezuela?
Well, I'm sure that Mark can give you a much better answer than I could. So I hope Mark will not be, let's say, upset. But Mark, I'm sure you can give much better answer.
Okay, Mark, give the better answer.
It's difficult. It's very embarrassing, and it fits into the approach of a country that doesn't really uphold principles, but is really merely in a policy of interest. I think that's what we can say. And of course, in that context, in that realm, corruption will be used if it is needed, if it is politically opportune.
Yes, this seems to be right. So the last question is from Anatad Marty. And I think each of you can have about 30 seconds on this. How can we persuade citizens in developed countries to care more about domestic and transnational corruption? And what has been the pattern of in regard to citizen concern in recent decades? Who would like to go first about that fundamental question, which I think is a very important one? Drago?
Yeah, for let's say for the start, I'm sure that these citizens have forgotten what are the consequences of corruption simply because of the material situation that most of them lives in. So if they would repeat the lesson and let's say try to understand what corruption is causing not only to the people living in developing countries but also developed countries, then they would understand that there's a need to do something against it. And unfortunately, no, people are only willing to learn when they already have faced some negative consequences. I really don't wish that that would be the final trigger for them to recollecting the need for the knowledge in this area.
Yes, that seems to me right. We might be about to get a very big lesson, but it might last a while. Does either Danielle or Mark want to add anything to that?
Just very short that especially with foreign bribery, it's always difficult to get people to understand that it's harmful because it happens in other countries. I've seen it in my own country. We always have the, like we say, the VOC mentality. We just do business abroad, and then bribing is just part of the deal. That's how they do it in these countries, and we don't have any problems with that because we don't feel it here. That's one. The other thing is that so people have to understand more and more, and we're on a good track. That it impacts because we are a global world. That it impacts us also if this happens abroad. But also the morality it spreads because if you bribe abroad, what's happening then in your own country? And then we come to what Drago just said is that people should really realize how disruptive corruption can be for the economic stability, for the democratic environment, for the rule of law. And I'm very passionate about trying to keep that in the picture for people because everybody's worried about a lot of things that are going on right now, but corruption are part of what's going on right now as well.
So I'm going to sort of wind it up now, but each of you will have a minute to sort of say what you think the most important thing of all is for audience members to take away from our very sobering and rich discussion. And I'm going to start in reverse order from the way we started at the beginning. So I'll start with Mark.
Yeah, well, I think we have to go back to this pausing situation. That is really the biggest challenge that we're facing at the moment, that simply one major country is opting out. And if you think that other major countries have never ever joined, like India and China, the situation is quite drab. What we can hope, though, is that the rest of the G7 countries will take over part of the responsibility.
Yes, I think that a lot will fall on the Europeans and others, and that's an enormous challenge now, given all the other stresses they're under. Drago, your comment.
Two things. First, just to reiterate what Danielle has said, you see, what we see today in the world, everything also has some or many links with corruption. And the second one, although we for sure we sound depressive today in our presentations, but you see, the world doesn't have the luxury to stop fighting corruption, so we just have to continue doing it. And there is enough good people and good experts around the world who will do it.
And finally, Danielle.
I just want to second that. I think that there are still a lot of people that are very passionate about fighting corruption. In that sense, there's still hope. And also, there will be new governments, new administrations. Actually, in my line of work now, I'm a private practice lawyer. A lot of companies also say, well, this will pass and then we'll go on again. So we're not going to change our way of doing business now just because things look a bit dark and different now. So we just have to face the horizon and keep going.
And the only concluding remark I would make, I've made my opening remark, I think this is absolutely fundamental to our future globally, and particularly where I am in European countries, but also, of course, in other high-income countries and very, very much in developing countries. There is no doubt that the attempt to eliminate or control corruption has been one of the most difficult and important tasks politically, both domestically and internationally, for generations. And it is unbelievably depressing that when some progress was being made, and I think some progress was made, it is being reversed actually in a significant way by the country that started all this. So it is a tragedy, but as in so many other areas where this tragedy is unfolding, others are, as participants have suggested, going to have to take up the burden, and it falls on them to do so. That must be the optimistic side. And the other optimistic possibility is that people will be reminded pretty soon how bad really corrupt government is, because we are getting some pretty horrifying indications of this right now. So with that, I will close this discussion. I think the panelists have been wonderful. I've learned an immense amount, which was not difficult given my starting point. And I've been very privileged to be able to moderate this discussion. So thank you for everybody.